Alrighty, again, this is We the People News. This is part 3, okay? Um, again, this is without prejudice and or without recourse, okay? I'm going to go ahead and stand on USC 1-308. All rights reserved. Not waiving none of it, y'all. Just for argument's sake, I'm going to go ahead and stand on also UCC 1-207. Alright, and I'm not an attorney, so anything I say or do is just my opinion only, okay? I'm not giving legal advice. Why? Because I'm not an attorney, okay? And I'm not trying to help these people out, okay? And like I said before, I am 100% a firm believer in jury notification. Judges has gotten out of control, and they really construed the judges or juries. They tamper with juries all the time, y'all. To be fair and honest, I've seen a couple of court cases when they actually asked the juries to leave because it didn't fit the court's narrative, right? Jury trial is different than trial by jury. Trial by jury, you just sit there and you listen to the whole court case, and then you actually make a legit ruling on it. Jury trial, as judges, gives you directions and say what you can and cannot do. So they're actually interfering in jury duties. That's my opinion. I'm not giving legal advice, okay? Alright, let's proceed forward, y'all.
People have ever been arrested. I'm guessing that a reasonable number of people have probably been chased off the 200-foot space outside a courthouse. Why are we ever going to have to face this?
Well, Your Honor, a statute like this is a little bit...
Again, right? Very few people have been arrested. How many people has to be arrested? Oh, then you got people chased off. Why is people being chased off? Just saying, y'all.
Like Chekhov's gun. It's lying around. It could go off at any time. Perhaps it hasn't gone off very many times in the past 40 years or so. But it's always possible that there is going to be significant public interest in protesting a particular prosecution. And in that moment, the court will have to decide very quickly whether the statute can constitutionally prohibit that protesting. Right now,
but that's not such a lay-down case for you, is it? I mean, think about Cox against Louisiana. The Supreme Court says the statute or the ordinance in that case, it assumes that serves a compelling interest and decides the case on a different ground in favor of the protesters because they were told that over there is okay, and then they were arrested for going over there. But they sort of assume that that's okay. And I'm having a little trouble understanding why this is, a grossly facially unconstitutional statute applied to...
Yeah, they keep on talking about statutes, but statutes do not override the Constitution. Period. So, I don't know, I'm like...
At least some cases applied maybe to the core cases that the state says it's designed for.
Well, Your Honor, the fundamental difference between this case and Cox versus Louisiana is that in Cox you had a content-neutral statute, and in Cox there was an intent requirement. And so that tailored the statute to an unlawful intent to interfere.
See, this content-based thing bothers me. I realize the Supreme Court says it's very important if there's any content-based anything. But I'm having a little trouble understanding how it can possibly be the case that it's a better thing for the state to have a regulation that prohibits all demonstrations, even like anti-Vietnam War or Black Lives Matter or something that has nothing to do with anything going on in the courthouse at that moment. It's okay to have that because it's content neutral. But if they just say not anything that might interfere with what's going on, not anything that addresses what's going on in the courthouse is a problem. Why works.
Well, Your Honor, even a content-neutral regulation would have to be narrowly tailored, and that was exactly the problem in United States versus Grace. And the trick is to find the right mechanism for tailoring the statute to the government's interest. And what the Supreme Court has told us is that content-based, facially
Government interests, not the people's interests, but the government interests.
Content-based mechanisms are presumptively illegitimate, but intent requirements, effect requirements, they're more legitimate.
Yeah, that's weird too, isn't it? Because these statutes are not probably designed to put anyone in prison, right? They're designed to chase people away, to tell them that it's illegal, and maybe even to arrest them. And then in the fullness of time, the cases get dismissed and nobody gets prosecuted. And if that's the case, if that's what the functional thing is, why doesn't...
Exactly. The statutes to go ahead and arrest them, chase them away, and not even prosecute them. However the damage is done. Somebody had to fork out money for bonds, attorney fees, or some whatever, all right, or been chased away from a public area.
Intent requirement help at all? Because why isn't there at least probable cause to believe that someone who's out there chanting with a large group of people with big signs about a case that's going on, isn't there at least wouldn't a reasonable person at least think there's probable cause to believe that they intend to influence what's going on in there?
Well, Your Honor, I think protesters will be a lot more comfortable, even when they're confronted by an officer and threatened with arrest, if they know that they can fall back on this intent requirement. And that's exactly what happened in United States versus Carter. Unfortunately, it didn't go the protesters' way there, but they wanted to make a jury argument, saying that under these circumstances, you should not infer that we had any intent to interfere with the trial. So if you have a single protester holding a poster board sign saying, this particular prosecution is unjust, he's holding it far away from anywhere where the judge or jury might enter. I think under those circumstances, it would be very,
you
very
said
difficult.
far away. Why is it within 200 feet of the courthouse? You're saying that's an unreason. If it was within 20 feet of the entrance, you wouldn't be here?
Well, Your Honor, I do think a 200-foot buffer zone is quite large. The buffer zone in Burson versus Freeman, for example, was 100 feet. The buffer zone in McCullen was 35 feet. So 200-foot buffer zone is quite big, but also there might be entrances in the courthouse where the judge and jury enter and different entrances where the public enters. And so someone who's holding a poster board sign protesting a prosecution, they say, I was holding that where the public enters. It was very unlikely that the judge or jury would ever have seen me. They were already inside the courthouse. Under those circumstances, I think it would be very difficult for a prosecutor to bring a prosecution saying you had the intent to influence a judge or jury. And similarly, I think police officers would understand that under those circumstances, and when you don't have the mob outside the courthouse, but when you have a few solitary protesters with signs, that the act does not apply to that sort of conduct or that sort of expression.
When you talk about intent, are you saying the statute requires intent?
This statute does not require intent, Your Honor. All it requires is for the defendant to have displayed a sign.
That's what I thought. That's why I didn't quite understand all this talk about intent. We don't have an intent statute.
Well, so, Your Honor, our point was that a constitutional statute can use an intent requirement. That was the statute in Cox versus Louisiana. That had an intent requirement. So it didn't prescribe the speech based on what was being said. Instead, it prescribed the speech based on whether or not it was said with an improper intent. And so that is the key distinction between this case and Cox. And I think that's what makes this statute unconstitutional. And I would note that this is
that if he holds something, let's say he's within 10 feet of the juror walking in, and he has a sign saying, free this person on trial now. It's constitutional so long as he doesn't intend that. He was just given a sign by a friend. Hold this sign. The guy says, I don't even know what it says. I'll pay you $5 if you'll hold this sign.
I think that would likely be constitutionally protected, Your Honor, because he wouldn't have the intent.
The juror doesn't know walking in whether he was paid or not, right?
The juror does not know any of that.
So the juror is likely to be just as influenced by the content of the sign, regardless of what's in the mind of the sign holder.
Well, Your Honor, as Judge Cote...
Right. Which goes back in what? Facebook, YouTube, news. So when you go into waiving the jury of any sort, way, or fashion. That's already doing 24 hours a day, 7 days a week. They just want to grab any little bitty power they can just to show force. Alright? And then we go again. We got people that not even trying to intent go to jail. Or intent and be shoved off a 200 feet area. Which, by the way, again, my last video or so, we're supposed to actually go out there and clog the streets in front of the building and regress our grievance every 20 years. Most people don't even know that.
Pointed out in her order, the court has lots of other tools at its disposal to address this problem. One of those tools is providing a prophylactic instruction to jurors at the beginning of the trial. Say, don't read anything anybody hands to you outside of the courthouse. You do not consider the prospect of jury nullification. You can also...
The state has to rely on that alternative?
No, there are other alternatives the state can adopt here. The state can also restrict all sign holding on the courthouse grounds, and that's what the D.C. Circuit held in Hodge versus Talcott, is that on the actual courthouse property, when you're not in a traditional public forum that has been held open for protest, the court has a lot more leeway, the government has a lot more leeway to restrict all expressive activity. Additionally, of course, there are obstruction statutes, tampering statutes that the state can enforce under various circumstances.
Do you regard the length of that 200-foot area as beyond narrow tailoring?
Your Honor, I think the length is significant. That is quite a large buffer zone, but I think the fundamental point for narrow tailoring here is New York is the only state that has a content-based courthouse protest statute. The federal government and every other state that has adopted one of these statutes uses an intent or effects requirement. And so this statute is really an outlier when it comes to constitutionally protected expression.
New York State I don't understand that argument. We hear that once in a while. What difference that 49 other states haven't done this?
Okay, so even if they create a statute with intent, that is still regressing the government, and that still would be unconstitutional, even with the intent. My intent is to regress my grievance and protest them. That's my intent. And they're saying the statutes, I'm not allowed to have the intent to do so, makes it unconstitutional, let alone accidental.
If this statute is within constitutional limits, what do we care that 49 other states didn't do it this way?
Well, Your Honor, I think the fact that 49 other states did not adopt a content distinction, which the Supreme Court has said is presumptively illegitimate, is strong evidence that a content distinction is unnecessary. And so given that content-based distinctions are inherently disfavored, the availability of a content-neutral alternative that's more closely tailored to the conduct that the government is trying to suppress is an example of a less restrictive alternative. I would also note that it's the state's burden under strict scrutiny to demonstrate that the law survives and that it is necessary to vindicate a compelling governmental interest.
Time, place, and manner restrictions, if they cover something that is content-based, always get strict scrutiny?
Pretty much always, Your Honor.
Pretty much?
I'm struggling to think of an exception. When you have a restriction on speech in a traditional public forum that is... I'm sorry, Your Honor?
Polling places.
So that the court applied strict scrutiny in Burson versus Freeman, and it upheld the law. And the reason it upheld the law is it said that there was a 50-state consensus that this was necessary. And so in that context, there was a very robust consensus among all the relevant jurisdictions that a content-based distinction within 100 feet of the polling place was necessary to vindicate the government's interests. Here, the government doesn't have the consensus, and it hasn't submitted any other evidence.
And you think whether it's constitutional, we just count the states. So if it was 40 to 10, that would be likely constitutional. If it was 35 to 15, doubtful. Is that how we apply the Constitution?
I don't think it's a math test, Your Honor, but the point is that the state has the burden of demonstrating that the act survives strict scrutiny. And so the state hasn't put it...
It's always been a math test. That's the reason why it's, 5-4 in the Supreme Courts. So I kind of laugh at that one a little bit, y'all. All right, so we're going to end it here and do one more, and that should end this. Okay? And again, the reason why I shortened these down a little bit is to give a way of thoughts and dissect a little bit better. And if you want to hear the same deal all the way through, go to Junkyard News, okay? And just go through the whole thing. I actually would go ahead, if you have time, to go through the whole thing with Junkyard News. Subscribe. Alright? And then maybe come to mine and kind of nitpick at what they're talking about. And how one side is trying to take your rights, and why the other side is trying to, like, uphold it. Alright? This will be the People News. Bye, y'all.